Mr. Stern? You may proceed.
Okay, thank you, Your Honor. Your Honor, I'm here representing the Committee for Health Care and 10 voters of the Commonwealth. This case has to do with Article 48, which, as the Court knows, provides a mechanism for the people of Massachusetts to amend the Constitution, even in the face of legislative opposition or resistance. The resolution of this case, the case that's now pending before the Court, will determine whether the people will retain that right or forever lose it. There's no question that Article 48 requires the legislature to vote up or down, one way or the other, on all constitutional initiatives properly placed before it. If there was any doubt, this Court made clear in the Doyle case decided last December that a vote was required, was mandated by the Constitution. So the issue today is there any judicial remedy for a blatant, repeated, and clear violation of the constitutional mandate set out in Article 48? There's no easy answer to the question, and there's no...
the answer might be probably no.
Well, the answer might be probably no, Your Honor, and I'm going to deal with...
Probably. I said probably.
Probably. And that's the underscore of probably, because there's certainly language in some of these courts, some of this Court's decisions, which would suggest that the answer might be no. But we think there are three reasons why the answer should be yes.
Mr. Stern, even if the answer is yes, and there are good reasons why the answer might be yes, it seemed to me that the one remedy surely cannot be a remedy that in and of itself is in conflict with the Constitution. So you can order redistricting. The judge can redistrict. That's not against the words of the Constitution. You can order money damages in some cases. Here, as the Attorney General points out, there hasn't been an affirmative vote, and yet you're asking us, I mean, the Constitution itself says there has to be an affirmative vote. There hasn't been an affirmative vote, so the remedy, it seems to me, that you are suggesting is itself contrary to what the Constitution requires. And that puts us in a little different posture, doesn't it?
Well, Your Honor, I think the question is not whether any particular, that result is contrary to the Constitution, because there's no, I don't think, for reasons I'll talk about, I don't think there's a textual answer to that question.
Right.
I think the proper question, and the one really squarely presented to this Court in a way that hasn't been presented before, is which imperfect remedy, which imperfect result is most consistent with the Constitution and most consistent with Article 48. It's very clear that if the Court does nothing, if it declares definitively forever, makes it a dead letter that there is no judicial remedy ever for a violation of Article 48, that Article 48, insofar as it retains the people's power to present to the voters a constitutional amendment, is a dead letter. There will be no enforcement, and there'll be no ability of the legislature, or willingness of the legislature to abide by Article 48.
Mr. Stern, what do we do if we order something and the legislature doesn't do what we order?
Well, that I think is part of the difficulty of coming up with a remedy, but I think it can be done. This case has none of the, let's say, characteristics which in the past has made the Court reluctant to basically provide a judicial remedy. There's nothing left for the legislatures to do. It's not like the Limits case or other cases, or even the Doyle case for that matter, where there was still something left for the legislature to do. There was an opportunity for the legislature to act. That isn't present here.
Just give me, Mr. Stern, forgive me. Just Doyle came down on December the 27th.
Yes.
Right?
Or the 6th. It was a few days after Christmas.
And I think we can recognize, in fact, we said as much, that until Doyle, a well-meaning legislator reading the Constitution could reasonably have concluded that a vote was not required, that the procedural decisions that had been made in the past, I think in one of our footnotes we pointed out that there were people who said as much. So what has happened in the wake of Doyle?
Well, in the wake of Doyle, there were two, as the Court noted, there were two pending constitutional initiatives presented by the people, pending and active before the joint session. There was the so-called same-sex marriage amendment, which was basically the Doyle plaintiffs, and there was the one which was proposed by my clients, the Health Care Committee. The Healthcare Committee, in fact, had received the 25% in the previous joint session. So they were in a different, and I would argue factually different and distinguishable position. When the legislature came back, I think on January 2nd, Your Honor, post-Doyle decision, there were two matters acted before it. In the case of Doyle, they took a vote, up or down, and the vote was down. And the amendment did not get the 25% required.
What do you say the remedy should be?
The remedy has to be the most consistent with the purpose of Article 48.
What is that?
Which is to order the Secretary to present it to the voters at the next statewide election. It's the only remedy that works. It's the only remedy which is consistent with the purpose of Article 48, which is to prevent the legislature, either directly or indirectly, from standing as a barrier.
So the upshot is, having failed in your duty to vote on the merits as per the Doyle case, we hereby order this on the ballot.
Well,
Yes.
essentially, you're asking it to be deemed a vote.
I think the deeming, and I know the Attorney General makes this point, Your Honor, the deeming phrase is, I think, a loaded phrase that doesn't quite apply. What I think makes sense is, what's the proper remedy? Is there a proper remedy? And I'm not aware of any case, and I don't think the Attorney General has cited any case in this Court's history, frankly, where the Court has decided that the matter is justiciable, in other words, it's capable of resolution by the judicial branch, where the Court has declared that there is a clear duty on the part of another co-equal branch to do something, where there are repeated violations to do it. In fact, within days after this Court spoke in the Doyle case, and this Court then failed to provide a remedy. I'm not aware of any case in this Court's jurisprudence where the Court has essentially said, we can't do anything, it's beyond our capacity to provide a remedy. And in answer to Justice Graney's question, it's not a, when you go through the possibilities, it strikes us that the least intrusive one, the one that does the least damage to the separation of powers, is to put it on the ballot, having in mind, Your Honor, that this Court, as it said before, does not check common sense at the door.
But doesn't that have the problem that the Chief Justice mentions, that you are putting on the ballot something that hasn't gotten an affirmative vote of 25% of the
It hasn't gotten that's correct, Your Honor. And it's not the perfect remedy. The perfect remedy would have been for the legislature to have done its duty. The question is having to choose between two imperfect alternatives. Which is the one that is most faithful to the power that the people retain for itself?
But there's nothing in Article 48 or elsewhere in the Constitution to take care of this contingency, is there?
There's nothing textual specific which does it. And of course, at the time of the debates, the only anticipated, clearly demarcated violation which the voters, which the people thought would occur, was the failure to agree upon a time to get together. And they provided a mechanism for doing that.
And one thing in your favor, I guess, for the remedy you want is that the first year when they took it up, the first session, it passed 153 to 41.
That's right.
So that's a pretty strong showing that perhaps the second time around it might have made it.
The 25%.
But wasn't the second time around a different legislature?
It is a different legislature.
So I don't see how you can draw any numbers.
And you've gotten
different
a
reasons,
statute
yeah.
passed in the meantime.
Yeah, but trying to figure out whether it's the appropriate result is obviously a policy choice. And I know, again, the reasons why this Court has refrained from having to decide this issue, which is, I call this crunch time now. The Court has to decide whether Article 48 survives or not in the form intended.
Mr. Stern, forgive me.
That's right.
I want to be extremely clear, because you are perfectly correct to say that in all of the other cases, to my knowledge, there hasn't been a statement by this Court saying this is the constitutional obligation of anybody. I mean, another branch of government, a district attorney, a lawyer, whatever it is, and then not had that followed in some way. So what are the specific, when you say repeated violations in the wake of Doyle, what are the specific examples where there have been repeated violations, where you say...
Oh, in the wake of Doyle, there's only been one violation. That's the failure to vote on this
on
initiative.
this one.
On this one.
Okay.
And it was done through procedural vehicle. The chair decided that it had been referred to a committee previously, and the committee never met, never reported back, didn't really exist as far as anyone can tell. And the chair determined that it required a 2/3 vote to get it out of committee. There were certainly more than 25% who voted, in favor of getting it back on the floor.
And what was the time period within which to get the second vote, because there had been one vote, to get the second vote, what was the time period within which that second vote had to occur?
You're talking about the first vote being at the joint session? It was this 2003-2004 session. This was a 2005-2006 session.
But what you're saying, after Doyle came down, they still had time to do it.
Yes.
How much time?
Well, it was that week. They met on January 2nd.
So that it was on that one day, right?
Yes.
They had the week.
Yes.
That's what I'm trying to be very specific.
Yes.
So Doyle comes down, as I said, I think it's December the 27th, right?
Right.
Yes.
And then they meet again on January the 2nd, and they vote on one of the two.
Yes, that's correct, Your Honor.
And they did not vote on this.
Yes.
And is there anything in the record that evidences in connection with either one of that there was an understanding that they were required by the Constitution to have that vote?
Well, part of the debate in whether to take it out of the committee, those who wanted to vote referred to this court's decision in Doyle and said the court has made clear that we need to vote. And admittedly, a vote to get it out of committee doesn't necessarily mean a vote on the merits. I mean, someone could, in good faith, say, I believe I need to vote up or down. So, we understand that vote necessarily doesn't translate one for one. And, of course, we also included in the record of appendix, Your Honor, email from counsel to the Senate saying that, referring to the Doyle decision, saying that the holding of Doyle did not require us to vote, or words to that effect.
Did not
require it, suggesting that it might be something short of a direct declaration or direct requirement that the joint session, in fact, vote on all, not just the same-sex marriage, but vote on all pending initiatives.
Well, the holding of Doyle didn't require them to vote. It just said you're supposed to vote.
Right.
Step up and do it. And then at the end it says the remedy would be at the ballot box.
Mr. Stern, if we agree with you, what's the rule going forward then?
Yeah. Here's what I think, Your Honor. It's a question I've been struggling with, because I do think this is probably the first and last time the court will have to confront this particular issue. And here's why. If the court decides there's no remedy, then that will be the definitive word, and in our view, Article 48 will die on the vine, and the rights of the people to do so and present a constitutional initiative in the face of legislative opposition will die. If, however, the court decides that there is a remedy, albeit imperfect, not the remedy that we would have chosen, but it's the one that we're confronted with now and the one we think does the least institutional damage, if that happens, then the legislature will know that there is a result. There is something that happens if they fail to step up to the plate and fulfill their constitutional obligation, which means that the only reason left why a legislature would ever fail to take final action as required by Article 48 is if they know that if 25% of the legislature have the votes, that vote will take place. If 75% think, or 75% plus one, believe that the votes aren't there, they will have sufficient weight in the legislature by any kind of procedural mechanism to force a vote and to vote it down. So I think once people know, the legislature knows that this is the result, I don't think there'll be another instance which will come before the court.
Could you have asked, I'm just looking at Article 48, could you have asked or done something to get the governor to keep that session in session until a vote was taken?
I don't think so, Your Honor, because I think the court's cases have said the governor does not have to do a futile act, and the governor, it was the last day of the legislative session, and I think it was pretty clear that the legislature had decided to adjourn without taking a vote. This was not a kind of something that got lost in the shuffle. This is not something where, This was literally days after the Doyle decision, and the court made clear that there were two pending initiatives. Every effort was made to get a vote, and the legislature
What was
essentially
the
thumbed its nose at Article 48.
What was the basis of counsel to the Senate's letter saying you don't have to?
Beats me, Your Honor. I read this court's decision in Doyle as saying, not directing by order, but unmistakably making clear if anybody in the Commonwealth had any doubts as to what Article 48 meant, we now make it clear that Article 48 requires a vote, up or down. And that's all the people are asking for and asked for at the time. The remedy, I see my time is up, Your Honor.
Let me ask you another question. In between the first vote of the joint session and the second non-vote, there had been comprehensive legislation passed, correct?
Yes.
Which parallels, overlaps, is similar to, different from this initiative petition?
Well, its basic purpose, which is to further advance health insurance for residents of the Commonwealth, is consistent. But this court certainly can't be in the position of deciding whether that supplements or is a fair approximation for a constitutional initiative. That then gets the court into the policy decisions as to whether it's good or bad.
Obviously, this court, because it respects the other two branches of government, is reluctant to draw a conclusion that there was a willful violation or willful attempt to ignore, what this court had said was a clear constitutional duty. And I'm trying to discern, and maybe you could help me by saying, beats me what the legal counsel had in mind. But what's the best argument? I mean, the legal counsel is a lawyer. He swears to uphold the Constitution and so on and so forth. I mean, what's the best argument that this, in fact, did not require?
Well, the best argument is that this court would not provide a remedy. That the counsel to the Senate may see in this court's prior decisions and some of this court's language that notwithstanding the unmistakable duty, notwithstanding the dominant purpose of Article 48, which has been a touchstone for this court's decision, that the counsel to the Senate and maybe some members of the joint session determined, and they may prove to be right, that this court will not provide a remedy for a blatant violation. The one last point I make, Your Honor, if I can just have 30 seconds, which is the remedy here, again, not a perfect remedy, an imperfect remedy, we would say is less intrusive and less overarching, if you will, on the other branch than some of the remedies that this court has used in other instances. It doesn't, it's more like the line item veto case, the opinion of the justices, where the court, if you will, deemed that an item was an item or part of an item for purposes of the Constitution. It's a little bit like Bromfield in that the court decided, here's your obligation, and if you don't fulfill your obligation, we're going to sell off state property. We're going to do some draconian things which certainly impede upon the legislative branch. It's more like Perez, where in the face of clear, continual violations of the Constitution, this court decided that the judiciary had the authority to modulate and calibrate its remedy consistent with the overriding purpose of the Constitution. So it's certainly not a slam dunk easy result, but in the face of repeated efforts by the failure by the part of the legislative branch, for them now to, and for the argument to be made, Article 30 prevents you, court, from intervening, is at the risk of being overly dramatic here. It's a little bit like the child killing his parents and saying to the court, we want special consideration as an orphan. Article 30 cannot be a shield against the requirements in Article 48.
Mr. Stern, you'll have to leave it there.
Thank you.
Thanks very much. Mr. Sachs?
Good morning, Your Honors. Peter Sachs, Assistant Attorney General representing the Secretary. The plaintiffs are saying to this court, if the legislature won't do its constitutionally assigned job, you should do it for them.
Mr. Sachs, do you agree that the legislature has not done its constitutionally assigned responsibility, has not carried it out in the wake of Doyle?
I don't think there's anything I can add to what was said in Doyle. There's certainly no dispute that the legislature did not vote on the health care amendment.
If the,
So that the legislature has violated the Constitution.
Well, I don't know if it's the Secretary's place to determine if the legislature has violated the Constitution, but again...
Well, it makes a big difference because, you know, we have to be pretty clear. I mean, if there's no constitutional violation, then we don't even get to the discussion of remedies. And I don't think that you can say, well, let's assume that it has, because that's a pretty serious situation and one that I can't think of another case where that is so clear, other than the clean elections case.
Well, we're not arguing that the legislature didn't violate the Constitution. What we are arguing is that the remedy the plaintiffs are requesting would violate both Article 30 and Article 48. It would violate Article 30 by involving this court in performing a task that the Constitution assigns to the legislature of determining whether a measure has 25% affirmative support in order to get it on the ballot.
When you use the term, quote, violate the Constitution, it seems to me you've got to keep two things in mind. One, the Doyle case instructed them that they were supposed to vote as part of their job and their oath, but didn't require them to vote.
That's correct.
That's number one.
And
number
if
two,
I may,
for all we know, they might have taken into account that the Universal Health Care Bill, or whatever it's called, that was enacted last year, kind of took care of the problem.
well, both of those are correct, Your Honor. First of all, the email from Senate Counsel that was referred to, and it's on page 72 of the record appendix, says the court ruled this morning rejecting the suit by Governor Romney and other plaintiffs. The court unanimously refused to issue any of the orders against either the President or the Secretary as the plaintiffs had requested. The court's opinion does contain statements that legislators have a constitutional duty to vote by the yeas and nays on the merits of all pending initiative amendments before recessing on January 2nd, 2007. These statements are unnecessary to the court's decision and are therefore not part of the case's legal holding. So I think what the Senate Counsel was doing was making a distinction between what the court said about the legislature's duty and the relief the court issued. And the court declined to issue any relief on separation of powers grounds. And that was really the holding, that the court could not issue that relief. But certainly there was a recognition of what the court had said. And as far as Chapter 58 and the passage of the Universal Health Care Bill, that was the subject of discussion, significant discussion, both when the legislature, the joint session met on this in, I believe, June 2006. And again, there were references to it when the joint session met on January 2nd, 2007.
If this matter had been considered at the Constitutional Convention, what is your opinion? What do you think would there have been a provision for a remedy? What do you think would have happened?
Based on our review of the debates, it was clear that the drafters of Article 48 viewed an affirmative vote, 25% affirmative vote by two successive legislatures as essential to the validity of the process. They repeatedly rejected attempts to take the legislature out of the process of amending the Constitution.
But if the hypothetical were put to them that the legislature wouldn't take the second vote, what would you theorize they would have said?
It's really impossible to say, but one can infer by the presence of constructive approval mechanisms elsewhere in the Constitution, including one that the 1917-18 Convention itself adopted in Amendment Article 63 regarding the governor's item veto power, that the drafters know how to create constructive approval mechanisms for inaction by one branch when they want to do so.
But it's also clear that they didn't anticipate. I mean, when there was this discussion, there was also the discussion about nobody, I can't even begin to think that somebody wouldn't carry out their constitutional duty.
Yes, and there was other discussion about...
I think you and I are probably the only two people that have read those constitutional conventions. No, I shouldn't say that, but up and down. The constitutional duty to vote, is there any other case where this court has ruled that either the governor or the legislature, another branch of government, not an official, not an individual, but a branch of government, the governor is an individual, but essentially is a branch of government, has a constitutional duty to do something, and that branch of government has not done that thing.
Well, the closest that this Court has come that I'm aware of are the Doyle case and the Limits case.
That we laid out and said here for the first time, and I'm going to say that until Doyle, I'm going to presume that until Doyle, any legislature could reasonably believe that he or she did not have a constitutional duty to vote.
Well, then I think the second part of my answer is there's no case that plaintiffs have cited or that we're aware of in which a court has issued a remedy that violates Article 30 in order to correct a violation of some other part of the Constitution.
That's not my question.
And the Court has refused to do so a number of times.
My question is there, what's the closest case, not getting to remedies, where, is there another case where we have said it is your constitutional duty to do something, and that branch of government has not done that thing?
I think Bates is probably the closest, the Clean Elections case, where the Court said the legislature has the obligation either to fund the Clean Elections law or to repeal it. And the legislature didn't do either one, so this Court crafted remedies, along with the single justice, that found funding for clean elections candidates, but did so within the bounds of Article 30. There was no order to the legislature to appropriate money. There was no order to the treasurer to take money out of the Treasury without an appropriation. The plaintiffs there asked for relief against the Secretary. They said, enjoin the Secretary from holding elections in order to put pressure on the legislature to do its duty. Just as plaintiffs here are saying, order the Secretary to put this measure on the ballot, to sanction the legislature so that they'll pay the price and they'll know that if they ever decline to vote on an amendment again, this is what will happen. And what this Court said in Bates was that misperceives our role as a co-equal branch under Article 30, and it turns the rule of law into a strategy game. So the Court did not order the legislature to do one or the other of the things that it was required to do.
Is there any other case, is Mr. Stern right, there is no other case where there is a constitutional violation by somebody? We cannot find a remedy?
I am not aware of such a case, but I think the more important principle here is that what the Court has said is it's often declined to issue relief against the governor or the legislature, and the Court said in the Town of Milton case and others, usually but not always, relief will be available against some other official.
Has this or a similar issue?
And this is the case. This is the not always case.
Has this issue or a similar one arisen in any other state?
Not that we've been able to find,
That
Your
is
Honor.
to say, and that's why I keep pressing you, I don't know of any case where the Court has, either by declaratory judgment or some other way said this is your constitutional duty, then when somebody doesn't carry it out, there's no remedy. The remedy may not be against the legislature. The remedy may not be against the governor, but there's always been some mechanism found. Let me ask a question.
But the Court has always done that within Article 30 bounds. And when we say there's no remedy, I think we have to recognize this Court has said on numerous prior occasions, including most recently in Doyle, there is a political remedy. And there are really two political remedies. One is to elect legislators who will take final action on all initiative amendments pending before them. The other is an amendment to Article 48 to correct what I think we all recognize by now is a flaw.
But there are breaches of constitutional duty where this Court has said there's no remedy. I mean, the Hancock case.
Well, I
said,
think
okay, McDuffie said you breached the duty, and then we get back and we look at the report of the judge and everything and say, well, things aren't going so hot, but there's no remedy.
Well, some members of the Court said there should be no remedy. Some members of the Court, I think at least a plurality, said there was no violation at the time of the Hancock case. But
Mr. Sachs, let me ask you this. I mean, you as always, very thoughtfully figure out what the problem is here, but essentially, the Article 48 language is mandatory. It's shall. And Mr. Stern makes, I think, a reasonable point that if there's no remedy in this case, it essentially strips Article 48 of any meaning at all.
I don't think that's correct, Your Honor, on several levels.
Tell me why.
First of all, the legislature has followed the initiative amendment process several times in recent years. It's taken varying amounts of political and other pressure to bring that about, but it has happened. Most recently in the case of the same-sex marriage amendment, in which the legislature took a vote on the merits at the January 2nd, 2007 session, giving the amendment approval, and then in the next session took another vote on the merits, disapproving it. That is entirely legitimate according to Article 48, and it is the people's process. That's what happens to an amendment on a controversial issue. Another instance in which the process has worked is the graduated income tax initiative amendment that was proposed in 1991. It was approved by 2 successive joint sessions. It appeared on the ballot in 1994, and it was defeated. So the process is not dead. It still works.
I'm not saying that the initiative petition process has never worked before. It's simply, I think Mr. Stern's point is, if you say that there's no remedy, then all future legislatures, essentially what you're then doing is saying Article 48 doesn't mean what it says. You've got to do this, and then you've got to keep up, and if a legislature wants to say, I don't want to vote, or a committee chair doesn't want to vote it out of committee, or, the Senate president or the speaker, agrees that it won't come to the floor for a vote, that's fine.
I couldn't agree that Article 48 doesn't mean what it says. It says, as the court has determined in Doyle, that the legislature shall vote. What it doesn't say, one way or the other, is what happens if the legislature doesn't vote. The drafters could have inserted language that said, unless the measure is defeated by a 3/4 vote of the joint session, then it shall be deemed approved and shall proceed either to the next legislature or the clerk shall certify it to the secretary to place it on the ballot. It's that kind of constructive approval mechanism for inaction that appears in numerous other cases, numerous other places in the Constitution, and that the plaintiffs are asking this court to read into Article 48, but it isn't there. Article 48 simply doesn't resolve this problem, and I think there were several mentions, you alluded to one before, in the 1917-18 convention. There was another point at which a member said, sometimes it's difficult to get a roll call vote, and his concerns were brushed aside. In retrospect, it appears that was done too hastily. But
the oddity of this particular thing is that, the gist of the convention was not to have a direct initiative petition. You can't just go out and get the number of...
For constitutional amendments, yes, as opposed to statutes.
And yet this little 25% one seems to be to protect the voters from, in essence, being flooded with initiative petitions saying, look, at very least, you've got to get 25%. You don't have to get if you get more than that, then it goes through the legislative process, but at least get 25%.
That's correct, and as plaintiffs have conceded, there's no way to tell from the votes that occurred whether this does have 25% support, yet they're asking you to order the secretary to act as if it did. And that is really asking you to step into legislative territory and say to the legislature, you didn't do your job, now we're going to do it for you. And I can't imagine a clearer violation of Article 30 than this court directly stepping in and performing a function that the Constitution assigns to the legislature. So there is no judicial remedy available here. There is a political remedy, several political remedies. Elect different legislators, amend Article 48. And as I mentioned in the brief, there is precedent for the legislature approving amendments to Article 48 that make the initiative process work more easily. Even though Article 48 was created and presented as a means of confronting and getting around an unresponsive legislature, one can't assume that when the functioning of Article 48 is detached from any particular substantive policy issue and considered as a process matter, that the legislature is going to refuse to make needed changes in Article 48. And the particular change I'm referring to is, I believe, Amendment Article 74, in which the existing requirement that the Attorney General write a very detailed description of a law, which had been used or had been applied in order to keep many measures off of the ballot and had created voter confusion, was changed to allow the Attorney General to write a fair and concise summary. And that was viewed as, and this Court has recognized repeatedly, that it allowed the process to work more efficiently. The legislature approved that proposal. In fact, the legislature initiated that proposal. That was not a voter That was not an initiative amendment. That was a legislative amendment, yet the legislature went along with it. When it's unhooked from a particular policy issue and viewed as a process matter, I don't think one can rule out that the legislature would consider fixing this issue one way or the other. Whether they do it by saying if a measure doesn't get a 75% disapproval vote, then it goes on to the ballot, or whether they do it by bringing the existing 25% approval provision into harmony with general parliamentary procedure principles under which a majority vote determines whether there is a vote on the merits. That's really up to the legislature. But there is a way to address this problem, but Article 48 and Article 30 don't allow this court to issue a remedy.
Thank you, Mr. Sanders.